Isn't your call at this point to render an opinion on whether the constitutional amendment in itself would be constitutional. At some point, will you render an opinion on that issue?
What has happened at times in the past is that there may be third parties who will challenge such a provision as to whether it should go to the ballot. It is not, as I see it, within the proper scope of my authority to decide that. Certainly never would be within my authority to decide because I agree or disagree with the measure. I will take steps to further sabotage it. I will try to be very careful about ballot amendments. And secondly, that would be a matter, if raised, for the courts to decide.
Is there like a 10-day window, though?
There is, correct. I believe that we have until Thursday to certify whether the summary of this provision is a fair and accurate statement of the provision submitted. We're at work on that as we speak, and we'll have something for you this week on that.
Do you think that there's a lot of partisan overtones to the lawsuits? It seems that in states where the Republicans hold the Attorney General's office, they're all filing the lawsuits, and the Democratic governors are opposed to it. And when the Democrats are in the Attorney General's office and the Republicans hold the governor's office, the governor's offices are actually, I think they're also trying to pressure their Attorney Generals or go other routes. So do you see partisanship?
Yeah, I typically, Laura, I don't get into characterizing people's motives. I think people can judge that and make their own judgments for themselves. It is not the case that every Republican Attorney General in the country has joined or filed one of these lawsuits at this point. A number have, some have not. There is at least one Democrat who's joined one of the lawsuits. The rest have not. I think many of the Attorney General at this point probably are still in the process of considering what to do. They didn't just jump up and make a move on the spur of the moment. And like myself, probably wanted to take some time to size up the arguments. I will refer you to a quote that I saw over the weekend that I thought was of interest. This is from Charles Freed, who was the U.S. Solicitor General under President Ronald Reagan, in charge of all litigation in the U.S. Supreme Court, who at the time was criticized as being too partisan in carrying forward the Reagan administration's ideological causes. He has said about these lawsuits, and I quote, "Anybody who proposes something like this is either ignorant, I mean deeply ignorant, or just grandstanding in a preposterous way. It is simply a political ploy, and a pathetic one at that," Freed said. Another story had the following quote from him: "My copy of the Constitution doesn't have an individual right not to be insured. I'm prepared to say it's complete nonsense." That's one perspective. You can Google that and find those quotes. Again, it's an unexpected perspective that this is simply a partisan matter. But, you know, this is a matter of judgment for us. How do we deploy the resources of the Attorney General's office? I know that others have said that they would like us to file this lawsuit, and we'll file it on their first day in office if they arrive here. And if so, that'll be their prerogative. On my first day in office, as you may recall, we had a pending lawsuit that I thought was controversial and ultimately lacking in merit against the paint companies that my predecessor had filed. And we set about a process to review that carefully, and over the course of the next month ultimately determined not to proceed with that lawsuit, and we dismissed it. I will say that not every problem is best solved by a lawsuit. If there are policy-based disagreements, then those should be fought out in the political arena and not necessarily transferred into the courts. But having said that, it is not, I think, appropriate for me to characterize motives as partisan or not. You can judge that for yourself.
Did you receive a formal letter from Mike DeWine, or was it just press releases?
I have received formal letters from the 8 Republican members of the Ohio Congressional Delegation and 21 members of the Ohio Senate on this, and they're in your package. I have not received any formal correspondence from Mike DeWine. What I have seen from him was the press releases.
Is it within your power to an authority, if you did find that it was a meritorious lawsuit, do you have the authority to sue the federal government? I mean, I know you sue businesses you think are ripping off people. I know you participate in defending state laws, because that's part of your job. Is it part of your job, if you did find it meritorious, you could sue?
Yes, I believe so. There might be some back and forth with other state officials in that case, either the legislature or the governor, potentially. It is my view that the Attorney General represents the state of Ohio. That's very clearly, I think, what the code and the Constitution say. This issue actually in a different form is before the Ohio Supreme Court right now in the Lake Erie case, where there is an issue of the Attorney General's authority, and we briefed that to the court, and we expect they will decide that sometime this year. There have been lots of other cases previously where there might have been disagreements among different officials, and they battle back and forth over who has what authority. But I think it's clear that the Attorney General, by Constitution and law, is the chief law officer for the state, and matters of litigation policy are within my judgment. And again, this is a question of judgment. It's a question of what are the legal merits of this lawsuit? What are the priorities of this office? What should those priorities be? People can have reasonable disagreements about those competing judgments. In my view, however, this lawsuit in particular does not have merit and would be a waste of taxpayer money.
If the state constitution were amended, this ballot initiative is successful, and then we have a state law or a state constitutional provision that is in basically direct conflict with the position you're stating, would you be obligated to defend that, or what position would that put you in?
That's an interesting question, and actually I don't think we'll cross that bridge unless or until we ever come to it. There were issues of nullification that came up before the Civil War, whether a state could nullify a federal law's impact within their borders. The Civil War seemed to settle that. The 14th Amendment, in addition, was very clear and explicit on these points. You had the same issues arise during the Civil Rights Movement and in the wake of Brown versus Board of Education in the South, where there were both statutes and constitutional amendments proposed and enacted and adopted that would have nullified federal law. The Supremacy Clause of the U.S. Constitution, Article 6, is very clear that federal law enacted by Congress is, and this is a quote, the supreme law of the land, and, quote, anything in the laws and constitutions of the several states to the contrary notwithstanding. So the Supremacy Clause is quite clear, I believe.